Hello and welcome to this webinar, To the Companies Act and Beyond. My name is John Churchill and with me is Lottie Mallin-Martin. We are both members of the Guildhall Chambers commercial team. This webinar is the latest in the commercial webinar series by Guildhall Chambers, and the next in the series will be presented by Richard Ascroft on the issue of company deadlock. Today's talk is a guide to alternative duties, which asks the prior anterior question of an alternative to what. We are aware that most commercial practitioners are fully experienced and comfortable in advising on what we would term normal or standard companies and the usual duties that are imposed on directors in relation to those companies. These duties stem partly from the common law and partly from equity and are recognised in section 171 to 177 of the Companies Act 2006. Today, we are looking beyond those normal duties and normal companies by looking at different contexts and asking how those duties differ and alter according to the entity concerned or the situation in which a normal company is placed. For example, we'll be looking at the context of an ordinary company and the duties on a director and how they alter post-liquidation. In other cases, we will be looking at the duties which are imposed in entities that sometimes look and sound like companies, but are different creatures of statutes. For example, the limited liability partnership and the community interest company. The starting point, which we'll return to repeatedly during the talk, is the duties owed by person A to entity B, if not express, are primarily equitable and shift according to the context in which they arise. This is recognised within the Companies Act itself at section 170, subsection 3 and 4, which makes clear that the, quote, normal duties are based on common law rules and equitable principles. So perhaps it is easier to think of duties at 171 to 177 of the Companies Act as a small space of dry land where duties arise, are imposed on an individual due to the nature of the entity and the title and status which a person has adopted in relation to that entity. Outside of that small area of dry land, we have to fall back onto the equitable principles and the general question of whether somebody is a fiduciary. Whether somebody is a fiduciary is a question which the Supreme Court has had to turn to repeatedly in the last year, firstly in the Hopcraft or car finance case, but also in the Mitchell case, which Lottie will look at shortly. The governing tests for a fiduciary is set out on the slide. A fiduciary is somebody who has undertaken to act for another in circumstances which give rise to a relationship of trust and confidence, and the distinguishing obligation is one of loyalty. When that obligation, a fiduciary obligation, arises, then the various duties which are now set out on the slide are normally imposed on an individual. Person A must act in good faith towards the entity concerned. They must not make a profit from their relationship with the entity. They might not put themselves in a position where their own interests and their loyalty to entity B conflicts. And person A must obtain entity B's informed consent before acting on their own behalf or on the interest of a third party. So the general test for working out whether particular fiduciary obligations arise will always be whether or not there is an obligation of trust and confidence which causes these duties to exist. But outside of that normal fiduciary context, the question is whether specific rules, either from contract or from statute, go further to change the obligations that are imposed on the person in relation to the entity. With that overarching question in mind, we'll turn to the structure of today's talk. Firstly, we will ask what duties are owed by the director after the company enters into liquidation. Secondly, what duties are owed by a member of an LLP to the LLP and other members. Thirdly, what duties are owed by directors of community interest companies, or CICs. And finally, what duties can be imposed on a senior employee by their employer. I will then turn to Lottie, who will deliver the first part of the talk on the duties owed by a director after a company enters into liquidation.
Thanks, John. Now, as John's alluded to help us answer that first question on our agenda, I'm going to cast the spotlight on the Supreme Court's recent decision of Mitchell and Jaber. So that was handed down in November of last year. Now, Mitchell is concerned with the consequences of Section 175(1) of the BVI Insolvency Act 2003. And the essence of that, certainly for subsection B, is that on the commencement of a company's winding up, the directors and other officers of a company remain in office, but they cease to have any powers, functions, or duties other than those required or permitted under this part. So we're concerned in Mitchell with the winding up of company MBI International in around 2011. And the particular individual that we're concerned with is the Sheikh, who owned that company along with many others. And the effect of the company's winding up in 2011 is that the Sheikh's powers as director came to an end. Now, Mitchell isn't just of academic interest for us. We have equivalent provisions on the issue of directors' powers in insolvency situations in the UK. So I've put those up on the slide here. Section 91 of the 1986 Act for Members' Voluntary Liquidation, Section 103 of the Act for Creditors' Voluntary Liquidation. In an administration situation, we turn to Schedule B1, paragraph 64. As for compulsory liquidation, well, I've set out two authorities on the slide there, Measures Brothers and Park Associated Developments Limited, which again speak to an outcome that the directors cease to have powers, functions or duties other than are prescribed under those particular sections. So the factual issue that I want to focus on that cropped up in the Supreme Court's decision is concerned with what we call the 2016 share transfers. So in February 2016, without the knowledge of the liquidator, the Sheikh signed two undated share transfer forms to transfer two share classes, focusing here on the 891K class shares from the company MBI International to one of the associated companies, JJW Guernsey. And the Sheikh purported to sign the share transfer forms for and on behalf of the company as its director. And it was in the context of that share transfer that we looked at the first issue and the appeal. And that was whether the Sheikh was in breach of his fiduciary duties to the company in affecting the 2016 share transfers. So the principal focus of that part of the appeal, the Supreme Court moved to an argument that liability as an intermediary or de facto fiduciary would arise only if a person voluntarily assumed the office of fiduciary. And so what the Sheikh was saying is that you can only become accountable for the functions and duties of a fiduciary if those functions and duties are legally capable of being discharged. So you can imagine how the argument ran in this particular case is, well, under Section 175(1)(b) of the 2003 Act, those directors' duties had ceased to have any effect on the commencement of the winding up in 2011. Now, perhaps it's just me, I don't think it is, but I think the finding of the Supreme Court, the decision of the Supreme Court isn't particularly surprising in Mitchell. What they decided was the Sheikh owed a fiduciary duty to the company in its purported exercise of fiduciary power in transacting with its property. Going back to the few slides ago from John about one of the duties that fiduciaries would owe. Now, the fiduciary duty of the company in this context extended to having regard to the interests of its creditors in the context of insolvency. And to that, we look to BTI and Sequana, the Supreme Court's decision from a few years prior, 2022. Now, as the courts recently explained in Hopcroft, the motor finance case, equity recognises the existence of fiduciary duties by analysing objectively the relationship between the parties to ascertain whether it involves a relationship of trust and confidence. And that's because the party has, or is treated as having, undertaken to act with that loyalty, which is described by Lord Justice Millett in Mothew, we saw on the slides not too long ago from John. But the relationship of trust and confidence is the consequence and not the cause of the fiduciary duty. And it exists because you look at the matter objectively and that fiduciary has undertaken, consciously or unconsciously, not to pursue their own interests. We see that from Lord Wolfe, Master of the Rolls, and Attorney General and Blake, that relationship of trust and confidence arises when one party undertakes to act in the interest of another. So I say, you apply that logic to the facts of Mitchell, the Sheikh had pretended to be a director with authority to transfer those 891k shares. And the fact that the recipient of those misappropriated shares was a company under his control rather than him personally was not relevant to his liability as a fiduciary in respect of that transaction. And so he was to be treated as though he were a director of the company whose powers hadn't been removed by Section 175 of the 2003 Act. And the whole point was that he couldn't hide behind Section 175 to avoid liability as a fiduciary. Wanted to flag one of the final points that come up on issue 1 of the appeal, which is that in the written case, the Sheikh had argued that you can't rely on the same act as both establishing or generating the assumption of fiduciary duty and a breach of that duty, and submitted to the court that you've got to identify, I suppose at some earlier point in time, that a person has assumed fiduciary duties before inquiring whether there's been any breach. And so that point was argued in the Court of Appeal as an improper conflation of accountability as a fiduciary and liability by treating the signature on those 2016 share transfer forms as rendering him fiduciary and leading to breach of the same. But that was given really short shrift at paragraph 55 of the Supreme Court's judgment, as they had said that the arrogation to oneself of a fiduciary power may render them accountable as a fiduciary without involving any breach of the same. But there's no reason why that arrogation of fiduciary power may not itself involve a breach of duty at one and the same time. So we've already indicated that Mitchell's not just of academic interest for us in that we have equivalent provisions in UK insolvency law, but I've thrown up on the slide here a couple of other instances where we might seek to apply the analysis in Mitchell to instances of defectively appointed directors. We've got an 1875 authority here, Gibson and Barton, or similarly to self-appointed directors in Canadian land reclaiming. And so even if you don't qualify as a director under the Articles of Association, you could be treated as having taken on the obligations of de jure directors. I'm going to hand back to John now to guide you through the duties owed by members of LLPs and directors of community interest companies.
Thank you, Lottie. In the second and third part of the talk, I'm going to address limited liability partnerships, LLPs, and community interest companies, CICs, together. That's because they are both relatively recent statutory creations which are designed in part to have new social benefits for either the entity concerned or for society. And on that basis, I think it's interesting to look at the time that those entities were passing through Parliament or afterwards to see what Parliament thought about how these entities would compare with existing companies. In the case of an LLP, the purpose of the LLP was to look and sound like a partnership. In the case of a community interest company, the purpose appears to have been to allow a particular social benefit, namely community interest, to accrue to a company as normally formed. If I start with LLPs, there's a quote on the slide at the moment from Lord Mackintosh of Haringey at the time that the bill in relation to LLPs was passing through the House of Lords. As it's clear from that slide, it was part of the purpose in introducing LLPs to give the benefit of a limited liability, previously a hallmark of a company, to a partnership. However, as the quid pro quo for that benefit, the government intended to ensure that there was a price to be paid. As the quote says, that in return for the benefit of limited liability, a price has to be paid, and the price that has to be paid is the price of transparency and in general of the application of as many as possible of the rules applying to limited companies. LLPs were created under the Limited Liability Partnership Act of 2000, which makes clear that the rights and duties of members arise in either A, the agreement between the members, or B, in default of agreement, by the default provisions which are provided under subsequent regulations. Section 6 of the Act then provides for the general principle that every member is an agent of the LLP. The default provisions provided under regulations arise under the LLP regulations of 2001, and for today's purposes, the key provision is Regulation 7. And I've summarised part of this on the slide. This ensures that as a default, every member has an equal entitlement to the management and profits of the LLP, and indemnity is to be provided to the LLP, by the LLP to a member for payments and liabilities in the ordinary course of the LLP's business. There is a duty, seemingly rather than entitlement, to participate in the management of the LLP, and there is no general entitlement to remuneration. Now, pausing there, all of those duties sound redolent of the obligations and entitlements that would arise under Model Articles of Association for a limited company. But when one goes further, down Regulation 7, then the obligations begin to sound even more like the obligations that would be owed by a company director as a fiduciary obligation. For example, there is the obligation to render true accounts. There is the obligation not to compete with the LLP without the LLP's consent, and to account to the LLP for any profits that are made in competition with the LLP. Finally, there is a duty which is close to that which arises under 175 to 177 of the Companies Act, that there is a duty to account for benefits received without the LLP's consent from a transaction involving the LLP or the use of the LLP's property. So pausing there, at the moment we have the starting point of the LLP agreement. In default of an express agreement, then we have the default provisions under the LLP regulations of 2001, which seemingly impose obligations similar to those which we'd recognise for a company director of a limited company. And we also have the application under the Limited Liability Partnership regulations of 2001 of a series of provisions under the Insolvency Act. There are two cases in which the courts have looked at how and to what extent directors' duties which would arise under a company are imposed on a member of an LLP. The two cases I want to look at today are the McTeer case from 2019, which is a decision of ICC Judge Jones, and also the decision in Davidson and Finnan, which is a decision of a Deputy High Court Judge. In the McTeer case, ICC Judge Jones said at paragraph 139 that the law concerning duties of a company director has been codified at sections 170 to 177 of the Companies Act 2006, and whilst this code has not been extended to or adopted for members of an LLP, whether they're designated as members or not, there is no doubt that the members are potentially subject to the same common law and equitable duties upon which the code is founded. Those duties are not displaced by the code except by mirroring. Application of those duties will depend upon each member's role, but in this case, he refers to the members, that those designated members were effectively the LLP's directors. Therefore, it is appropriate to refer to the law specifically applying to the duties of directors as though it referred to members, unless the context clearly provides otherwise. Now, when that decision was reviewed in the later Davidson case, which was a decision by Mr. Hugh Sims KC, sitting as the Deputy High Court Judge, the decision was looked at in the context of a duty that was said to arise by members of the LLP to have regard to the interests of creditors, what we know as the sequana duty, and which would arise under section 172, subsection 3 of the Companies Act 2006. And it was argued in that case that a similar provision should be made within an LLP for members to consider the interest of creditors, and this question was arising on a strikeout summary judgment point. The Deputy High Court Judge thought that the point was arguable. There was some query raised about whether the McTeer case was entirely correct and whether the point had been fully argued before the court on that occasion as to whether or not you could simply transpose Companies Act duties as imposed on a director across to an LLP. But it was decided in the Davidson case that it was at least seriously arguable that the director's duty to consider the interests of creditors could be transposed across to an LLP because, if not, there was a potential deficiency in the laws of LLP which would leave creditors of an LLP more exposed than they would in the case of a company. What both of those decisions indicate is that where members look and sound like directors in relation to an LLP, there is a judicial willingness to have regard to the duties that would be owed by a director to a company when determining what the scope of a member's duties to the LLP should be. If I move on to the next statutory creature, which is a community interest company, or CIC, there are two extracts from relatively recent House of Lords debates on the issues of CICs, which I think indicate nicely the tension involved in creating an entity which sits somewhere between being a charity and a normal company. On the one hand, there is a concern that the regulations imposed on a charity are somehow watered down in the case of the CIC, and on the other hand, there is a concern that the profit and commercial purpose which normally underlies a company should not be wholly diluted in the case of a CIC. If we see in the first quote, which is from Lord Morris of Haringey, now sitting as an opposition member in the House of Lords, the question is asked of why the minister would think that there are organisations that, quote, decide that they do not wish to register as charities but as community interest companies. Why are they trying to avoid that sort of regulation to protect the public? Clearly there is a concern that a CIC may be used as a vehicle to avoid the regulation that would otherwise fall on a charity. In the response from the government, there are 2 points to underline. The first is the government flags the point that a number of people have decided to use CIC as a really useful vehicle. That's why by 2024 there are seemingly 30,000 in existence. The other point that the government underlines is that part of the purpose of a community interest company is, quote, to distribute dividends back into the company and to incentivise people to invest in social benefit. If we look briefly at CICs themselves, they were created under the Companies Act 2004, and the 2006 Act takes effect subject to that part of the 2004 Act, pursuant to Section 6.2 of the 2006 Act. A community interest company has to, as the name would suggest, satisfy what is known as the community interest test, and that is whether a reasonable person would consider that the activities of that entity are being carried out for the benefit of the community. Now, the Community Interest Company Regulations 2005 make it clear that something is not able to satisfy the community interest test if the reasonable person might consider that the activity benefits only the members of a particular body or the employees of a particular employer. The starting point is the community interest companies generally fall under the same purview as the 2006 Act, and therefore the director of a community interest company has the same duty under Section 172 of the Companies Act to promote in good faith the success of the company. But what does success mean in the context of a community interest company? Lord Goldsmith dealt with that point when the bill was passing through the House of Lords, the bill being the Companies Act 2006, back in February 2006. And Lord Goldsmith said that for certain companies, such as charities and community interest companies, it will mean the attainment of the objectives for which the company has been established. One issue which arises in community interest companies and one of their defining features is what is known as the asset lock, and that provides that a company shall not transfer any of its assets other than for full consideration. Now, with that brief background to community interest companies in mind, it's worth looking at the duties that are imposed on a director of that company, and I'll focus in particular on the question of director remuneration. If we look at those issues that we've passed through already, how in relation to director remuneration does one ensure that assets are only transferred out of a community interest company for full value? How do you manage to balance that competing concern between incentivising people to proceed with social benefit whilst at the same time ensuring that a director is remunerated only to the extent that they are able to receive full consideration for whatever they get from the company? This issue isn't covered off in the case law, but it has been dealt with by the Office of the Regulator of Community Interest Companies in some guidance. And the guidance which is provided by the regulator is to say that a community interest company would not satisfy the community interest test if it ostensibly is established to benefit the community, but in fact consistently sets its director's remuneration at a level which means that the company is left making little or no profit for distribution to those causes. And so the overarching conclusion that one comes to on a CIC is that there is likely to be an enhanced Section 172 test, which is reinforced not only by the enhancement of what success means in the context of a CIC, but also by the asset lock. The conclusion that the regulator comes to is that it is clear that as a general principle, the remuneration of a CIC director should be no more than is reasonable, having regard to the contribution which they make to the success of the company and the benefit that it provides to the community. In other words, when one looks at a CIC in the context of director remuneration, there is going to be a more onerous director duty, because not only does a director have to ensure that the remuneration looks and sounds reasonable, but it has to look and sound reasonable having regard to what money is left in the community interest company to be directed towards its other objects and purposes. Before I hand back to Lottie, I'll draw together some threads that can be arrived at looking at both LLPs and CICs, which are these special statutory creatures. They are both created with the clear backdrop of directors' duties imposed on a normal company clearly in mind. To some extent, the case law on LLPs demonstrates there's a willingness by the courts to look to Companies Act law when deciding what duties are owed by a member to the LLP. In the CIC context, the net effect of the community interest test and the asset lock has been to create a director's duty which goes beyond and is apparently more onerous than that which would normally arise under the Companies Act. The other key point to flag before moving on is that to date, in both of these areas, there is relatively little case law, and there's some debate about whether these entities really sit clearly in a defined place that is separate from the duties that would arise on a director under the Companies Act, or whether more freedom or more regulation needs to be imposed on either a CIC or more freedom in the case of an LLP. With those brief conclusions, I will hand over to Lottie.
Thanks, John. For this final part of our talk, I want to spend a little bit of time talking about the duties that are owed by employees, particularly senior employees, to their employer. And I don't want to focus on those employees who also wear hats as a director, because I, as I say, suspect that you're all pretty comfortable dealing with the relevant provisions of the Companies Act on duties owed by directors. We're focusing here on duties owed by employees who don't also wear that hat. And I've thrown up on the slide here just 6 of the duties that might come to mind when you're dealing with senior employees. Express contractual duties. I mean, we're looking at the contract of employment here, and anything that's caught in the employee handbook say the duties might be for the currency of the employment relationship. They might post-date that relationship. Our classic PTRs for non-competes, non-solicitation, non-dealing, non-poaching, and express confidentiality clauses. We've got circles, I suppose, 2, 3, and 6 on duty of loyalty, fidelity, fiduciary duties, and duty of care, which arise during the currency of the employment relationship only. And then our duty of confidence, and allied to that, trade secret regulations, so far as the individual employee is exposed to, has access to confidential information which they are aware is to be kept confidential, then that duty might be breached during the currency of employment relationship or indeed at some time later. But we could spend a whole session just talking about even some of these duties on the slide, but perhaps it won't come as a surprise that I want to throw a spotlight on the issue of fiduciary duties owed by senior employees, given that's been something of a theme through mine and John's talk today. Also, there has been a recent decision of the High Court which has offered really helpful guidance on when to identify fiduciary duties owed by senior employees who aren't directors, and so I want to put that case on your radar if it's not there already. So, fiduciary duties owed by employees. Well, it seems to subvert that usual inequality of bargaining power relationship that we tend to think exists between employer and employee. And so courts aren't readily going to find that kind of duty being imposed on an employee, sometimes no matter how senior they are. And so the employee needs to be in a position of trust in relation to assets or employees of the employer, such that equity demands that fiduciary duties be imposed on them in addition to their usual employment duties. And we see the test really coming from the decision of Nottingham University and Fishel from 2000. So in determining whether a fiduciary relationship arises in the context of the employment relationship, it's necessary to identify with care the particular duties undertaken by the employee and to ask whether in all the circumstances he's placed himself in a position whereby he must act solely in the interests of his employer. And getting this kind of finding from the court that you've pleaded out through your claim in some sort of business protection context, I suspect, might not just be good for remedy if there is something to grab at by way of a loss to the business. But what's really helpful to remind ourselves of is that fiduciaries are always subject to a duty to disclose their own misconduct. And we see that from Court of Appeal's decision item software, UK Limited and Fasihi, which is 2004 Court of Appeal. In that case, Mr. Fasihi had failed to disclose his own misconduct in seeking to divert a contract to his new company, again, during the currency of his employment. And fiduciaries arguably also owe an enhanced duty to report and discourage other damaging activities, not just their own, but damaged misconduct by others. See that in British Midland Tools and Midland International Tolling, decision of High Court in 2003. Now, sometimes there's a tendency to think that senior employees, senior managers will be fiduciaries without more, but that kind of match is not so precise, and we see that from the case law on this issue. What we tend to say is that an employee might be a fiduciary if they're entrusted with employer's money or other property, or they obtain it by virtue of their position with the employer. If they're responsible for particular employees and they can use those employees for their own benefit, or they're in possession of trade secrets, i.e. more than just information that they might accrue during the usual course of employment. So like I say, senior managers in charge of day-to-day running of a whole division might not without more be regarded as fiduciaries owing the duties to their employer that John explored on one of the very first slides in this session. And we can see that in a case called Reuse Collections Limited and Sendall and other. And so this was a manager who didn't attend board meetings, didn't have high-level responsibility for strategy or financial matters, notwithstanding that they were responsible for a whole division of the business. And as I said, there's been recent High Court authority on the question of when someone is a fiduciary, and we see that in Dare International Limited and Solomon and another. Now, in this case, we had two senior traders in the global energy markets, Mr. Solomon and Mr. Hikmet. They weren't directors. They'd resigned to go work for a competitor, and they expected to be placed on garden leave. Now, for those of you who tend to deal with business protection cases quite often, will know that those employees would hope to be going on garden leave because they can join their competitors sooner if there's any question mark over the enforceability of the lengthy restrictions they might find in their PTRs. So they both thought they might go on garden leave. Mr. Solomon was put on garden leave for, I think, 2-3 months. And Mr. Hikmet wasn't put on garden leave at all. And so both of them then went on sick leave. Mr. Solomon went on for an existing chronic condition he had, and Mr. Hikmet said that he was experiencing stress and anxiety, which, as a matter of fact, in that decision of the High Court, was found not to be genuine. And so ultimately it was found to be a ruse to avoid going back to work and hope that he could join the competitor sooner. So thinking back to those circles on a few slides ago, this case threw up a whole suite of different issues for determination at first instance on the enforceability of 12-month PTRs for non-competes, breach of confidence, breach of express contractual duties during the currency of employment, and also question of breach of fiduciary duty, which had been pleaded by the claimants in that case. But the case was concerned principally with conduct on the part of the two defendants during their notice period. So nothing that they had done pre-notice. Now, let's focus on the guidance that was offered by the court on when you might identify fiduciary duties. There were 6 relevant factors that we see at paragraph 341 of the judgment, and I've put them up on the next couple of slides to have regard to. So you've got to think about the seniority of the employee, the extent of responsibility for, autonomy in relation to management of the business or part of the business, degree of autonomy afforded to them, or control in relation, control exercised by employer in relation to specific obligations, whether they're entrusted with particular property. We're not just dealing with physical property here, we're dealing with intangible property like confidential information. And particularly the question is whether they're relied upon to deal with that for the benefit of the employer or say for only authorised purposes. Fourth, whether the employee is entrusted with relevant initiatives and responsibilities in which they are required to act solely in the interests of the employer. Number 5, whether the nature of the employee's role or responsibilities is such as to leave the employer vulnerable to abuse, unless the employee acts solely in the best interests of employer. And that number 5 shouldn't be taken for granted. That is a really high bar to reach. The nature of the breach, finally, number 6. What the court said at paragraph 341 is that a fiduciary obligation will more readily be found in the case of bribe or secret commission. So with those guiding principles in mind, the court came to deal with, say, not only the question of enforceability of the 12-month restrictions, but whether there had been breach of the express contractual provisions and breach of the fiduciary duties on the part of Mr. Solomon and Mr. Hikmet during that notice period that they needed to work out but ultimately didn't. So in Mr. Solomon's case, it's found that owed a fiduciary duty when trading with the employer's own capital. That, I don't think, is particularly surprising an outcome. But where the claimant had missed a trick is that they had pleaded the fiduciary duty and sought to connect it to the claims that they were bringing, but the allegations that they were relying upon referred to that period of time in the notice period. And so the allegations of them didn't involve any breach of fiduciary duty or even breach of confidence, and that might have, looking at our guidance from the previous slides, misuse of confidential information that might have also given rise to fiduciary duties. So no fiduciary duty or breach of fiduciary duty was made out against Mr. Solomon, I should say. Mr. Hikmet, similar point applied in relation to fiduciary duties owed when dealing with the employer's capital, but in a slightly different position to Mr. Solomon, in that he had taken that unauthorised sick leave and he had misused confidential information and passed it on to his new employer, no doubt trying to leave a good impression. Now, that information that he was passing on was the kind of thing that had been entrusted to him purely for the employer's benefit. And so he wasn't entitled to share it. That had put him in breach of his duty of good faith, breach of his duty of loyalty, fidelity, frankly, a number of the breaches of duties that we'd explored on the circles and slides a little moment ago. It placed him in a position where his interests were conflicting with those of his employer. So he owed a fiduciary duty, not only pre-notice, but also during the currency of his notice period, and it was found that had been breached. And so, unsurprisingly, we're left the position where, frankly, the only thing that was found against Mr. Solomon was that he'd failed to turn up to occupational health, and the 12-month restriction on the non-compete was in theory enforceable, but given the length of time he'd been off, not just through garden leave, but also authorised genuine sick leave, coupled with that, the undertakings he'd given to trial, he'd already had the benefit of a 12-month restriction. So nothing further for Mr. Solomon to do. Mr. Hikmet, slightly different position, having not been placed on garden leave, taken unauthorised sick leave. The PTRs were enforceable for the balance of the 12-month period, which he had not, or for which the employer had not already got a benefit. And then in addition to that, springboard relief was sought in respect of the unfair competitive advantage Mr. Hikmet had gained by misusing the confidential information, and that was assessed at being worth about a month. So all in all, running for about 13 months, that restriction on Mr. Hikmet. Well, thank you everyone for joining us for this session on duties of the Companies Act and beyond. John and I are going to join you now for a live Q&A, and we look forward to seeing you on screen shortly.